There are three co-equal branches of government. The legislative branch that creates or crafts legislation that the executive puts into action based on the guidance of the judicial, to which the Supreme Court belongs, that instructs how to implement the law based on their interpretation of it. A clarification the High Court reminds all and sundry regarding the highly controversial issue of an ex-governor/convicted rapist and double murderer thought to be among those eligible for early release as a result of the good conduct time allowance law being put to use. PTV's Mark Vitalco has more.
The Supreme Court clarified that it did not order the release of convicted former Mayor Antonio Sanchez of Calauan, Laguna. According to SCPIO Chief Attorney Brian Hosaka, the implementation of Republic Act 10592, which increased the good conduct time allowance of prisoners, is not within the jurisdiction of the Supreme Court. He said the law can be applied retroactively.
Like all laws, the implementation and execution of RA 10592 is left for the executive branch of government. Again, the judiciary or the Supreme Court only interpreted RA 10592 and ruled that it be applied retroactively.
SC explained that the RA 10592 was a law enacted by Congress in 2013, amending certain provisions of the revised penal code. Some important amendments under RA 10592 include the increased number of days credited for GCTA, additional deduction of 15 days for each month of study, teaching, or mentoring service, and the expansion of the special time allowance for loyalty for prisoners under preventive imprisonment. In other words, persons deprived of liberty who are qualified to avail of the law can have a substantial reduction in their respective penalties.
These are the inmates. They were asking that, considering that the IRR had specifically mentioned that it was a prospective application, they went to the Supreme Court questioning that. No? So because of the petition, the Supreme Court ruled that it does in fact based on existing doctrine in criminal law, that if a penal law is favorable and advantageous to the accused, then it can have an retroactive.
Meanwhile, different groups gathered in front of the Department of Justice to call on the authorities to stop the release of Sanchez. They asserted that the DOJ and Bureau of Corrections should not forget the misdemeanors and infractions on record of the convicted mayor as perfect excuse to not reduce his 7 counts of reclusion perpetua sentence. For SC, the decision on matters concerning the good conduct time allowance law is in the hands of the executive branch of government.
Perhaps we will just have to wait for the particular branch of government, in this case the executive.
Mark Fetalco for The Nation.